Welcome everyone to the next in our series of mining webinars. Today I'm joined by a colleague of mine from Paris, Alban Dorin, who's going to talk to us today about OHADA law and its relevance in the mining sector. So Alban's going to give us an overview of the OHADA requirements, what they are, and some key points that those of you involved in the mining industry should look out for. I hope you enjoyed this session, and please give us any feedback you.
Thank you, Rachel, for the introduction. I will do a very brief summary of the OHADA legal framework for those who are not familiar with OHADA. OHADA is the French acronym for the Organization for the Harmonization of Business Law in Africa. It was created in 1993, initially by 14 West and Central African nations by the Treaty of St. Louis in Mauritius. The objective initially was to harmonize business law and foster economic development in West and Central Africa. In fact, today, most of the sub-Saharan and Francophone jurisdictions are not members of OHADA, and there are currently 17 member states which are members of OHADA. The OHADA Treaty has created a number of institutions, such as the Supranational Court of Justice, in order to ensure uniformity and consistent legal interpretation across the member countries. It also introduces the concept of the Uniform Acts, Act Uniform, which are the instruments by which the harmonization of the business laws of the member states is achieved. Today, there are 10 uniform acts which have been enacted under the OHADA Treaty. The Uniform Act on Security Interest, on cooperative law, on corporate law, on general commercial law, insolvency law, arbitration, mediation, carriage of goods by road, execution proceedings, accounting law, and financial reporting. However, the Uniform Act do not cover all relevant areas of business law. It does not cover, for example, mining law, contract law, civil law, administrative law, tax law, labor law, insurance law, property and land law. So it is really important to bear in mind that while the Uniform Acts have a very broad scope and supersede any existing national legislation, they must be combined with other regional or national laws or regulations. We are often asked the question of where the OHADA legislation or Uniform Acts stand in the hierarchy of rules and to what extent it has been introduced in each national legislation. Looking at the pyramid in the slide, you will see that the OHADA legislation sits at the top of the hierarchy, just below the Constitution, and has the same value as in the other treaty. And this also applies to the 10 Uniform Acts. Again, it means that the OHADA legislation supersedes and prevails over local laws and regulations, and the Uniform Acts do not require any local implementation measures, so they apply directly in each member state. This is important because it ensures a consistent legal framework in each Francophone member state. For an investor, it also means that a number of concepts will sound familiar when investing in different OHADA jurisdictions. Why is OHADA law relevant for mining projects? By way of reminder, there is no Uniform Act on mining. The mining laws in the OHADA region remain subject to local mining codes, although a common code of the West African Monetary Union has harmonized the mining codes in the region. In practice, among the 10 Uniform Acts, the most relevant for mining finance transaction is probably the Uniform Act on Security that was enacted in 2010. This Uniform Act was actually encouraged by the World Bank and is very heavily influenced by French law governing security interests. It helps to facilitate the financing of projects within the OHADA region by providing the lenders with a complete security package without impacting the project operations. In mining transactions, the OHADA Uniform Act on Corporate Law Companies is also relevant with respect to the corporate structure of the local mining company, which is generally incorporated either as a SA, Société Anonyme, SAS, Société par Action Simplifiée, or SARL, Société à Responsabilité Limitée. The OHADA Uniform Act on Arbitration may also be relevant in mining project if a contract is governed by OHADA arbitration. And obviously, the OHADA Uniform Act of Insolvency may also apply if the local company becomes insolvent. In this session, we'll focus more on the OHADA Uniform Act on security. Focusing now on the OHADA security law, as is the case in any civil law jurisdiction, multiple security documents are required generally for each type of asset. Contrary to English law, there is, for example, no concept of floating charge and no security assignment with respect to contracts, although security over receivables is possible. A typical security package under OHADA law may include, for project financing, the following security. First of all, the share pledge over the shares of the local company. The type of share pledge depends on the type of company, and one of the security over shares covers all financial instruments and may include the bank accounts of the pledgor where the dividends are paid. Generally, we also very often seen an assignment very similar to the French law one, or a pledge that is taken on local law receivables, which may be insurance claims, intercompany loans, or any receivables arising from project contracts, for example. It is also common to see pledge over movable assets, such as mining equipment, stockpile. Less often we see a business pledge, as generally the holder of the mining title is an SPV without existing business. But if a business pledge is taken, then it covers various assets such as goodwill, equipment, and IP rights, for example. Another security which is required in mining project under OHADA law is, of course, a pledge over the local bank accounts, which may be in local and foreign currency. A mortgage is, of course, an important piece and covers all real estate assets of the project company, and also the mining license, which is in most mining codes characterized as an immovable property. And although not specifically covered by the OHADA legislation, the mortgage is generally taken over the mining license. Local guarantees may also be granted by local companies subject to any upstream guarantee issues and possible exchange control restrictions, as will be explained in the next slide. This is, of course, in addition to other security that may be taken at the level of the parent or other group companies in any lender-friendly jurisdiction. As a quick reminder, there are three options to enforce OHADA security. The first one is the self-help remedies, what we call the pacte commissoire. This option exists if the lender and the pledgor has included this option in the relevant security agreement. This allows the lender to enforce security without any court involvement. It's, of course, very useful to have this option in the security document, but in practice it has been seldom been tested in major projects in Africa. The public auction is the second option to enforce security under OHADA law. This follows a formal court process, and the relevant assets are offered to third parties by public sale. The third option is the court ordered allocation of assets, which is basically a petition from the secured creditor for transfer of the secured asset in its name. Focusing on the security agent and the registration of OHADA security, a few words on the security agent. The security agent was created by the Uniform Act on Security in 2010, and now the OHADA security agent can perfect, manage, and enforce any security on behalf of the secured creditors. its role is quite close to the role of the security trustee under English law. And the security agent may be a domestic or foreign financial or credit institution. It doesn't need to be licensed in country, and obviously, if the security agent is not appointed under OHADA law, it can be appointed and registered security under any other foreign law. Moving to the registration of OHADA security and the registration cost. This is obviously very important in mining projects in the OHADA region. As a general principle, almost all security documents will be required to be filed with the local company's registry, which is called the RCCM, for enforceability purposes against third parties. For mortgages only, it will have to be registered with the relevant land registry. The registration with the tax authorities is generally optional. Unfortunately, the OHADA treaty and the OHADA laws have not harmonized the registration costs across the OHADA member states. So the stamp duties and registration costs with the RCCM range from nominal fees to more than 1% of the secured amount. And this applies to each security document which is registered. So the registration cost can be very significant if the registration costs are more than just a nominal amount. For notary fees this has to be anticipated with respect to mortgages. Otherwise, notarization is not required for other security other than the mortgages. How to try to mitigate the registration cost? In practice, for the jurisdiction where the registration costs are very high, given that the cost of security is calculated on the basis of the secured amount, it is not necessary that each asset secure 100% of the amount of the financing. For example, it doesn't make sense that an onshore bank account pledge secure a financing of $100 million if it is anticipated that no more than $10 million will be credited on the account. So an allocation of secured amounts must be made between the various security documents on the basis of the negotiated budget for registration if the fees are very high, and also depending on the value of the underlying assets. Generally, of course, the share security will cover most of the asset and would be secure for the full amount. The stamping is another example of a possible way to mitigate the cost. The idea of upstamping is the full amount of the financing on day one, but if an early trigger event occurs, then the lender would be entitled to register the full amount of the financing. This obviously requires that POA be granted to the security agent for such purpose. But of course, the cost of registration of the additional secured amount may require that the security agent advance the funds. The upstamping solution may be an idea. It hasn't been tested so far by local courts. In addition to the OHADA laws and to all mining and environmental licenses which are relevant for a mining project in the OHADA region, the exchange control approvals must be anticipated. Most of the OHADA countries are members of the West African Economic and Monetary Union or the Central African Economic and Monetary Community. And for those who are not members of this regional economic organization, they have their own exchange control regulations. But the regional organization have issued specific regulations on exchange controls, which are particularly burdensome and must be really well understood when implementing a project in the region. As a general principle, most of the financial transactions must be performed through an authorized intermediary bank, which has a banking license. The local bank is in particular in charge of ensuring compliance with the exchange control regulation, and most of the funds must transit through this local licensed bank, and this must be anticipated in advance. Specific authorizations must also be obtained to open offshore accounts or onshore accounts in foreign currency. This in practice can be an issue to structure the project accounts. And we've seen in recent transactions that the Central Bank of West Africa, for example, and the local authorities have become very reluctant to issue authorizations to open accounts in foreign currencies. And it has become quite challenging to obtain approval from the central bank for this purpose. Another issue that we've seen in recent transactions is the fact that under the West African Monetary Union regulations, a guarantee granted by a local company is considered as an investment made abroad by a local company, which means in practice that a local company granting a guarantee cannot guarantee more than 25% of the financing made available from a foreign lender, which is obviously an issue. However, this limitation does not apply to security interest, so there is no limitation in the typical security package, which relates to the project assets. But note that with respect to local guarantees, there is generally a cap of 25% that has to be also taken into account. Another foreign exchange issue that must be anticipated when structuring a transaction is the need to repatriate the sale of minerals within 1 month of shipment, and this may also be considered as such proceeds are generally required to repay the loan offshore. So that may also have to be taken into account for the flow of payments onshore and offshore. Other specific issues apply pursuant to the CIMAC regulation, which have become also much more stringent since the new regulations in 2018. Also note that filings with the Central Bank of the West African Economic and Monetary Union and or the Ministry of Finance with respect to loans must be made for statistical purposes. This slide is to provide a very basic overview of the impact of insolvency on the security package under OHADA law. The concept of insolvency under the Uniform Act on Insolvency dated 10 September 2015 is really a cash concept. The concept is called cessation de paiement, suspension of payments. And the suspension of payment occurs when the company is not able to meet its current liabilities with its available assets. So it's really a cash concept, and once the suspension of payment occurs, the company must open judicial recovery proceedings called redressement judiciaire or liquidation proceedings. The impact of insolvency of the local company on enforcement of security includes, first of all, a failed enforcement, which means that the security will not be enforceable as from the opening of the relevant insolvency proceeding until the end of the proceedings. The second impact is the prohibition of payment, which means that the company which is insolvent cannot make a payment unless specifically authorized to do so by the insolvency authorities. And the third consequence is really the hardening period. A number of transactions, including the creation or the perfection of security, may be challenged between the date of actual insolvency and the opening of the relevant insolvency proceedings. Note that the start of the hardening period can be backdated up to 18 months before the opening of the relevant insolvency proceedings. Also note that closeout netting is not recognized as such under OHADA law, which may be an issue for hedging transactions, which may not be terminated in accordance with their terms. So it's really important, of course, to mitigate the insolvency risk, and this requires some close monitoring of the local company, also including a number of early trigger events, early event of defaults in the finance documents, and also being able to enforce security at an upper level in a more friendly, lender-friendly jurisdiction to avoid any of these enforcement issues. This presentation is really aimed at providing a general overview of the key issues that must be considered when investing in the OHADA region, and probably the two main issues that we discussed that must be anticipated as early as possible in project finance are the regulatory and cost issues, as these issues may have a significant impact on the structuring of the project in the region.
Thank you, Alban. That was a very detailed overview of OHADA and its requirements. I hope you all found that useful. We'll be holding our next webinar session, which looks at joint ventures and their relevance in the mining industry. We're very pleased to have had a lot of feedback on our webinar series, so please do get in touch if you have ideas for future topics we should cover, or if you have any questions on those we've covered today or in previous webinars. Thanks a lot. Bye-bye.